All right on the dot. We've still got people coming in, but I'm going to make a start. Uh, so we're going to get this webinar rolling. Um, we are talking tonight about the fundamentals of will making. And I am going to stay on the slides mainly. If you have questions as we go, down the bottom of your screen, it may be hidden, but if you move your mouse down towards the bottom, you should be able to find the chat box. There is also a Q&A box. So those two boxes, put some questions in. I won't be able to see them as I go because I'm looking at my own shared screen, but I'll come back to questions at the end. And for those who are watching a replay, any questions that you submit through the replay screen get emailed to me and I will respond usually within 24 hours. So hopefully I answer all the questions as we go and you don't have anything that that you're left uncertain about, basically. So, who am I? For those of you who don't know me, my name is Jackie Broman and I'm the owner of TBA Law. I've been practicing for a fair while and then took over another firm in 2012, created TBA Law. So started in Nagambie and we've now got Wallen, Seymour, Romsey offices. And we've got a little space in Melbourne if we had to go down for appointment only. So it's really just a serviced office. But at the moment, you know, no one's really going into the CBD, so that's on hold. Now, I started out doing general practice, and my practice still does a lot of general legal work. But the reason why I started going deeper and deeper into the estate planning field was because I saw some of the dissatisfaction with people with disputes about wills. But one of the main ones that sort of pushed me to really go and do my master's degree in this area and do the extra 3 years of deep dive study was because I had a friend at the time in the DPP and she was disturbed by a case. It was coming up to sentencing and she was sentencing a woman who'd been found guilty for running a red light. No drugs or alcohol in her system. It was just a strange accident. This woman ran a red light and killed a young couple who were crossing the street. That young couple had come down for a getaway weekend from New South Wales to watch an AFL match. And they left at home two very young boys. Now, it was about 18 months since this young couple had been killed and my friend was prosecuting the woman and there'd been victim impact statements done for the sentencing and the court was able to hear that those kids for the last 18 months since their parents had died had been in and out of family court for the whole time because their grandparents on either side of the family didn't like each other and they were fighting over the kids and over the money. So that is the last thing those parents, I would imagine, would have ever wanted for their children. They hadn't left any wills and so it was just a mess. And so that's really what pushed me to dive deep in this area. So did the master's degree, and that funny little logo down the bottom there on the screen means something to other lawyers. It means that I've gone through a special 12-month accreditation process and passed. So if you want a specialist in an area of the law, you can go to the Law Institute of Victoria and ask for a referral to a specialist. In the area of wills and estates, there's only about 80 of us in Victoria. To put that in perspective, there's about 20,000 lawyers all up in Victoria. And there's also a little image on the other corner of my dog, and my other love is being out on the ocean, surprisingly enough. So that's a little bit about me. I do enjoy fishing, and a lot probably because it gets me away from the computer and the phone, maybe. But I certainly find it very, very peaceful and meditative. And then in the small periods of action when you're fishing, the adrenaline's pretty fun. And that's my dog. He would jump overboard any chance he got because he wants to chase the waves. So, yeah, just a little bit about me, I guess. So moving along, in terms of estate planning, look, 50 years ago, the world was a lot simpler, wasn't it? So estate planning wasn't this huge concept that it is now. It was getting a simple will done. And that was it, really. These days, things have gotten more and more complex. Families are more complex. Blended families, people own assets in multiple jurisdictions in Australia or potentially overseas. There's been a lot of tax changes. Superannuation is now compulsory. It wasn't 50 years ago, that's for sure. People are living longer. People are having more health problems at the end of life and dementia as a result of living longer. And just generally, because we're wealthier as well, a wealthier country in many respects, how we own assets is more complex. So I guess we are really just focusing on the fundamentals of a will tonight. But what I am going to be doing is running one of these webinars every 2 weeks up until the end of the year to sort of cover off a lot of the topics that arise quite regularly and that I really want to educate people about. But as I said, tonight we are mainly jumping into what it's all about to get a good will done and what you need to focus on. So many people, when they think about a will, and rightly so, they're just thinking about who they're going to leave their stuff to and how much they're going to leave someone. And that's great because most people come in to see me with a fairly good idea about who they want to get what. What they don't completely understand is how to make that happen and how to choose the best people to actually make it happen as well. And so that's why I help them go through to choose those crucial roles and the people in their lives that are most relevant to go into those roles. If you choose the wrong people in these crucial roles, sometimes that can cause the mess in the estate rather than anything else. So it might not even be how you divide your estate up between people. It may just be the personalities that are involved that cause a dispute, which is completely unnecessary. And so it's worthwhile spending 5 to 10 minutes at the start of an appointment going through the family tree and getting a bit of an understanding of the personalities of the people involved, understanding who potentially is the controlling person, whether there's major sibling rivalries, who has got their nose out of joint over certain things in the past, who works well together and who doesn't, who communicates well and who doesn't. Because from the perspective of an executor, so the executor is the person who is responsible for seeing that your will, that the wishes in your will are actually done. It is the executor's legal responsibility to collect in the assets, make sure everything's wound up, and then distribute in accordance with the will. So you can see that their role and how they run that is pretty important. If they're not communicating well, if they're not telling people what they're doing, if they're being cagey, if they're being slow, all of these things can make beneficiaries start getting a bit anxious. And this is usually when a beneficiary then would call me and saying, you know, my brother or sister or whoever is appointed as executor and they're not doing their job, blah, blah, blah. What can I do about it? And a lot of the angst is unnecessary because it's pretty easy just to keep people informed and to run things very smoothly. And most of the time, an executor is not doing the wrong thing at all. It's just a personality issue. So that's why having a good think about who you want as your executors is important. You can have up to 4. Yes, a beneficiary can also be an executor. In fact, it's probably preferable. So, you know, if you had 4 children, I would generally recommend to someone that you put all the 4 children in together, because then there's no one who gets their nose out of joint about not being favoured. Again, it depends on the family dynamic, but once you appoint an executor in your will, it's not to say that they'll even agree to do the role. They're not compelled to act. So if you select all 4 of your kids, when it comes to the time that you pass away, 2 of them might bow out and leave the other 2 to it, or they can then feel like they were treated equally and make it their choice whether they act or not. The only main requirement, I suppose, is if you have young children, so children under 18, there has to be at least 2 executors if there is someone who benefits under the will as part of the residuary of the estate, so the main pool, a percentage. If you're just leaving a small cash legacy to a child, that's easy enough to deal with, but you really need 2 executors at least. And that's mainly a requirement that comes through from the Supreme Court. And if you don't, the Supreme Court will ask for a surety to stand as guarantee against the estate. And you really don't want someone to have to do that for you, or for the estate to have to buy an insurance policy that things will be done right for the minor. So 2 executors for a minor, up to 4 generally. 1 by themselves can be enough. And yes, a beneficiary can be an executor. Now, the trustee. Usually the executors become the trustees. So it's a little bit of a grey area about when they cross from being executor to trustee, but it's usually when the executor has collected in all the funds and paid everything, and they're just then holding the funds for distribution, they generally become the trustee, because essentially their role is done, and then all they're doing is holding funds until they distribute. And again, if there's a minor child, for example, they may be holding the funds for years and have to invest it until the child's old enough. So their role becomes the role of a trustee. And they've got all the legal duties that a trustee has in terms of not acting in conflict of interest with their role, and they've got what are called fiduciary duties to make sure that they maximise the money, that they do the right thing by the person that they're acting as trustee for. And the other crucial role is a guardian. So again, this is where there's a minor child. So under 18, a parent really should be appointing a guardian for their children. And if not one, then multiple. You can have them joint. You could have alternates in case the first one you chose can't do it or chooses not to do it. But just like the story I told towards the beginning that compelled me to work in this area, if those parents had done the most basic wills, even if it was just a handwritten will kit, and said, such and such is my executor, such and such is my guardian, and everything goes equally to my kids, those kids would not have been in the situation they were in. So really crucial. But I could bang on about that a lot, and I won't. But if you have any more questions around that, In a couple of weeks' time, I'm going to run another webinar on what an executor's role is and what they have to do as part of probate and deceased estate administration. So if that's something that is more relevant for you, or if you know you've been appointed as someone as executor, then perhaps jump on that one, because I'll answer all the questions in relation to that in that other webinar. While I'm talking about wills, I really should talk about superannuation as well. And again, I'm running another webinar in a fortnight, which I'm going to dive far deeper into super about. But a lot of people don't realise that your superannuation is not covered by your will by default. So your superannuation is a special kind of asset. And like I was just talking about trustees before, the trustee of your super fund holds the super for you. It's not your asset until you're old enough to take it. So you have to tell the trustee of your super fund who you want your super to be paid to. It can fall back into your estate and be covered by your will, or you can direct for that to happen. And depending on your situation, sometimes I'll suggest that you do that. But basically, there's a limited range of people that you can actually pay your super to direct rather than through the will. And sometimes this is also a strategically good idea. So, sorry, I just had the warning that the internet might be unstable. So I hope you're catching what I'm getting. But the replay will be recording exactly what I'm saying. So you'll also get the replay. So for superannuation, there's certain categories of people you can pay super to directly. And those include your superannuation dependents who are spouse, children, stepchildren, or someone who's financially dependent on you. So those are your 4 categories essentially. Now those are limited categories. And when you think about younger people, or, you know, even older people who don't have a spouse or children, they're really limited to only being able to direct their super into their estate. And then there's a slight difference between who you can pay your super to and then who will be taxed. So essentially, if you pay your super direct to a spouse, or even if you pay your super through your will to your spouse won't pay tax on your super when it comes out. So it's usually tax-free to your spouse. Superannuation can be tax-free to children if they are under 18 or if they're still full-time students under 25. But otherwise, children will pay tax on superannuation that is paid to them. And the tax rate they pay is usually about 15 or 16%, because you've usually paid some tax putting the money into super. But you'd like to dive in and get a little bit more advice about that. But basically, there's not much you can do in that scenario except try and direct your super to whomever is going to pay the least amount of tax if you've got one. Now, coming back to how to actually tell your super fund what you want done. The document to use is called a binding death benefit nomination form. So your death benefit is basically the lump sum that's going to come out once you pass away, which includes your accumulation fund, so what you've paid in, and also any life insurance that's there as well. So the full amount is your death benefit. So with the binding nomination, it is not something you can just jump online and do. It is a form that needs 2 witnesses, just like a will. So you need to print that form off your super fund's website and do that nomination with 2 witnesses. Now, on a lot of funds, including industry funds, that binding nomination will expire every 3 years. So you do have to watch that to make sure that it remains binding if you don't want the super fund to make their own choice, which is what they can potentially do. If you don't have a binding nomination, the super fund will call for applications. Your spouse, your children, your stepchildren, everyone can apply, and then the super fund will make their own decision. You can just have a non-binding nomination. I don't know many scenarios where I'd recommend having a non-binding nomination, but basically if you make a binding nomination and you let it expire after 3 years, it goes back to just being a non-binding nomination. So it's really just an indication to your super fund about what you'd like, but they don't have to follow it. So that's a quick rattle off about super. And like I said, I'll go far deeper into super and estate planning in another couple of weeks if you watch out for that webinar. All right. So part of the reason we do a will is to make sure that we capture all our assets and they all go to the people we want them to go to in the way that we want them to go. So particularly for people with, slightly more complex situations, family trusts and things like that, we want to also make sure that the control of what you've built up during your life ends up with the right person. And you want to make sure that your hard-earned cash and assets, when they pass to your beneficiaries, are also protected in their hands. And there's quite a few different things you can do there as well. Of course, you can just leave legacies to people directly, and that's what the majority of people do, which is fine. But you can also do some fairly smart and tricky things in your wills too, if you really wanted to. Now, I've been talking a lot about leaving funds to minor children, and that the executors would hold those funds as trustees for the minors until they're 18 to receive their inheritance. Now, that is called a minor's trust, and that is what is set up automatically if you leave something to a child who's under 18. A lot of the time where clients of mine have children, I then recommend that they extend those minors trusts out until a child, a minor beneficiary, is 25 is my favorite age. So you can extend that minors trust from 18 to 21 to 25 to 30, whatever you like. And then we look at the terms of what the trust is. So when the executors are holding the money for the beneficiaries, for those children, do they have to just lock it away, or can it be used for their education? Could it be used for something specific for them? Could they, for example, have an advance on their inheritance if they were ready to buy a house? Could they have an advance on it if they wanted to take a year to travel overseas? So it really depends on the parents and what they value and what they think their children should or shouldn't be able to do. The other thing that the trust could pay for is, for example, further education, tertiary education, or even potentially lease them a place to live. So all these things, we can build in all sorts of flexibilities into these trusts. There's a whole lot of other trusts and things as well that we can touch on. Depends on what beneficiaries you have. Disabled beneficiaries, I'm certainly going to be talking about in a few weeks' time as well when I talk about blended families and complex situations. But another kind of trust to touch on briefly, and these kind of trusts are often talked about by accountants and financial planners because they recommend them. And I think that they're worthwhile too, but if someone comes to me saying their financial planner wants me to set up a testamentary trust, I'll still question whether it's the right thing for them. And what I'm talking about here is that we can set up a trust that protects your child's inheritance from a future spouse, from creditors if they have a small business, and it can give them further tax benefits as well. So that's called a testamentary discretionary trust. And instead of your kids inheriting cash, they essentially inherit an investment vehicle with their inheritance inside it. So it's a separate legal entity from themselves. which adds that aspect of protection. And there are tax benefits for your grandchildren and great-grandchildren potentially through that trust as well. So there's just some extra things that you can do if you really wanted to in your will, that I wanted to make sure that I draw your attention to in terms of asset protection. One other trust to briefly mention is called a life interest as well. So if you were concerned, for example, you might be in a blended family situation, about leaving your house to your new spouse, you might just give your new spouse a right to reside in the property, and then ultimately the kids get it, so that you've protected that asset is ultimately going to go to your kids, and that your new spouse won't sell it and whittle the funds away, or who knows what might happen. It depends again on the family structure and what you're particularly concerned about, because you ultimately know the personalities certainly better than I would, and how they are going to cope after you're gone. So moving along, I wanted to briefly touch on capacity too in the last bit of our half hour together, before I get into what I can do for you in TBA law. And capacity is important, particularly more so in Victoria recently, because in the last 5 years or so, the law in Victoria has changed a little bit and stopped people from being able to claim against an estate as easily as they used to be able to. So now, where people are unhappy with a will, they sometimes look for other ways to contest it. And that might include challenging the validity of the will itself, and whether the person who made the will actually knew what they were signing or doing at the time. So how you actually do your will also comes into play with this. So whether it's signed correctly can be really important, particularly when you're thinking about someone doing a handwritten will or doing a will kit. So you want to make sure that the person making the will handwrites it themselves, because I've had a few wills have a lot of issues and take more than 12 months to get across the line, where the spouse has written the will out for them, and then the court thinks it's implied that the person didn't actually know what was written, that the spouse was really writing the will for themselves, what they thought the person should want. Other things would be if there is any question around medication that the person's on at the time, whether there has been an early diagnosis of some kind of dementia. It's always handy to have a mini mental test or some kind of letter of capacity from a doctor as well at that point. So all of these things are important to make sure that your will stands up. And like I said, it's happening more and more that people will look for a way, a more legal, technical way to try and dispute a will if they can't do it the traditional way. So we just want to make them as watertight as possible by making sure that it's absolutely clear that the person making the will knows what they're doing and that it's absolutely what they want. From a legal perspective, there are a whole lot of questions that I need to ask when I have concerns that someone may not have capacity. And this is also why it's good to see the person alone sometimes and not with their family, not with their children. So again, if you bring an elderly parent in to see me, don't be offended if I ask to see the elderly parent alone. It's just to make sure that they do know what they're doing, and that no one can accuse you as well, of the person coming in with the parent, of trying to unduly influence, which is certainly probably not what your intention would ever have been. But if you've got that one sibling who, you know, just wants to cause trouble somehow or another, that's the way they can do it. And so that's what we're protecting against. So I'm just going to take a sip of water for a minute because I talk really fast when I get going. And what I'm going to do is quickly have a check in the chat box. So if the super contributions are post-tax, I believe there is no tax payable by beneficiaries. That's correct, yes. So in that case, there would be a PAYG statement that would be issued saying, you know, the amount that was taxable and the amount that was non-taxable. So it's not necessarily the case that there's a blanket 15% on the whole amount. So yes, you're right there. Question. If you set up a testamentary trust with a firm and then do a new will with a new firm, do you have to set up a new trust? So the testamentary trust itself sits in the will. So whenever you make a new will, it automatically revokes the previous will. So if you do a new will, you need your testamentary trust in that as well. Just to make sure though, you may have set up what's called like a family trust rather than a testamentary trust. So a family trust is something that operates while you're alive. So if you're thinking, well, I've set up a family trust and that's operating, and then you do your will, they're two separate things completely. But a testamentary trust is by nature a trust that is set up in your will. And so if you do a new one, you need the new one to also include a testamentary trust, because the old will is automatically revoked when you do a new will. So I hope that's answered that. All right. So moving along, like I talked about with one of the earlier screens, there are a lot of aspects to estate planning these days. And so this poker chip, this little image, is what we cover at TBA Law in our family legacy plan as part of our estate planning. So we look at how you own your property and whether you need to change how you own it. Particularly for couples, we try and make it as easy as possible if one person in the couple passes away. So joint property ownership is usually preferable. When property is owned jointly, it means that it transfers to the other party without too much concern, because we want to try and avoid probate, mainly because of the time that probate can take, and because when you're grieving your spouse, it's probably the last thing you really want to be doing. So joint property ownership is usually the way we try and go. And sometimes we need to change how property is owned. And particularly when you're thinking about bank accounts, you know, bank accounts freeze if they're in individual names, but not if they're joint names. So that's something to contemplate as well. So wills are obviously part of the estate planning process. We also make sure that we cover off the need for enduring powers of attorney. So they cover financial and legal decisions while you're still alive. Executors in your will don't have any power over your assets until you pass away. So sometimes people mistakenly think, oh, I've got a will so such and such can look after me if something happens, but no, you need powers of attorney for that. The appointment of a medical treatment decision maker is what the medical power of attorney is now called. So that changed in 2018 in Victoria. So even though we've had all these law changes in the last 5 years, anything done prior to that is still valid. It's just that we've had some really needed updates, to be honest. We look at advanced health care directives as well. So these work closely with your medical power of attorney and really leave instructions about your wishes. If you can't make medical decisions for yourself, what you want your medical treatment decision maker to actually follow. We look at your super and we look at the binding nominations and we help you do all those as well. We talk about testamentary trusts. We work out what trusts are most relevant for you, if any, and we make sure those are in there. We do cover your life insurance as well. We sort of ask what you've got and look at the beneficiary nominations on that as well. Particularly if your life insurance is in your super, that becomes part of that whole assessment process. But on some life insurance, you can nominate beneficiaries, on others you can't. So we have a close look at all of that. If you have minor children and you are appointing guardians, we also give you a form to be able to leave instructions to your guardians as well. So there's a lot of things that you sometimes don't even think about as a parent, because it's hard to think what would happen to your children if something's happened to you. So in that form, we talk about, well, how do you want your children educated? How do you want pocket money to be dealt with? What extracurricular activities are important for you? Do you want them to be involved in some kind of community organisation? Like, is the CFA important to you and your family? So you want that to continue through your kids. So all these sorts of things you can leave instructions about. Family trust appointments. So if you have a family trust already set up, we have to make sure that the control of that goes to the right people. Your personal effects list and your memorial instructions are not something that we like to include in your will. So we tend to encourage you to make those as a separate document. Particularly memorial instructions, they're not binding in your will anyway. The only thing binding in your will is whether you want to be buried or cremated. Other instructions are just wishes. So we tend to try and put those into a separate document. So these are all the things that we need to consider when we're doing our estate planning. And that's all included in our family legacy packet plan that we have. And it's not all that hard to do. So this is the process essentially. So if you wanted to get your estate planning done, we send you an initial package for you with a few brochures and to start collecting some information. It's not necessary that you even get that information back to us before the first appointment, really. It's just a guide for you to start collecting together your thoughts and information. Because in the first appointment, we basically know what we're wanting to ask, and we get everything we need in that first appointment so that we can do drafts for you. We email those drafts to you between the two appointments. If there is anything missing from the first appointment, we do all that between the two appointments. If there's a family trust deed we need to look at, we need to speak to your accountant or your financial planner, that all happens in between, and we finalize the drafts into a final position via email. You come along to your second appointment, we sign everything, it's all valid and done by then. That's usually a 2-week process, and then it's done. We deliver all the final documents to you after we've had any acceptance forms that need to be signed by powers of attorney. So we just polish everything up and then send you a set of certified copies so you have those at home in case they're needed. Because the last thing what tends to happen is that, people have accidents or pass away outside of business hours. So we're not going to be open necessarily when you have a crisis. So we want to make sure you've got those on hand. Another question. Yes. Okay. So I guess I'll cover that off in a minute in terms of cost. If I just move on to the next screen. So we do everything that I've just talked about for a couple for $1,100. If you didn't need powers of attorney and things like that as well, you're looking at wills for a couple to be about $750. If you want complex testamentary trusts, add an extra $500 to it. But if we're talking about a minor's trust, that's all inclusive. So you get everything that I was talking about on that poker chip slide for $1,100. Or if you don't need the whole powers of attorney, you just need the super and the will, $750 for a couple. And you're all done with minor's trusts and all that stuff in there. More complex testamentary trusts is the $500 extra, but that's sort of where you're sitting in terms of expectations. Cost for a single person. So a will for a single person, 500, 750 for the full package for a single person. And where do people keep their wills? And who do you tell? So, good question. Your will is your confidential document, so it's up to you who you want to tell. We won't tell anyone, and we won't release a copy of the will to anyone unless you tell us to. At two of our offices in Nagambie and in Romsey, we have a big strong room which is fireproof, and so we offer that as a free service to keep all your original documents together, and you can put whatever else you want in our strong room as well, so that's free. So we do that for most of the people who do their wills, and then we give you a pack of certified copies, and if you ever want to take them or move them anywhere, that you can do that for free. That's no issue. It's just keeping them off site and in a fireproof place is particularly important, I think, for Victoria. Unfortunately, there's still no central register for powers of attorney. If you're really concerned, you can register your will at the Supreme Court for a fee. Did that answer that full question? And who do you tell? So in terms of your estate planning process, I'm generally someone who really wants people to be as open as with their family as possible about what they're doing with their estate planning. Because the other thing that causes a lot of disputes after someone passes away is people's expectations not being met. They're surprised and then they're upset. So you don't necessarily have to show them the will, but certainly ask someone if they're happy to be your executor. And potentially, you know, we also provide you with electronic copies. So maybe even give your executor an electronic copy. When we send you the pack of certified copies, all the documents also have our details on the back. So if anyone's unsure about where to find the original, and they find your copies at home, they contact us. Yep, the original's with us, no worries. It's all there. So that's sort of generally how it works. Another question that then a lot of people have is, well, what happens if, you know, your firm merges or it changes or whatever? And this does happen a lot. I'm quite often hunting down wills from the 60s and 70s from a firm who no longer exists. The Law Institute in Victoria is actually compelled to keep a track of where people's documents go. So, you know, if a solicitor in the 60s, their partnership broke down, the two partners went their separate ways, all the wills went with one partner to this new firm, then that firm was acquired by this new firm, and then this is who you need to contact. So we can always track it back. It's very rare that a will is lost. So I hope that answers that question as well. So we're coming to the end. So I wanted to say thank you for sticking with me. I really hope that you got some useful information out of that. And like I said, I'm running one of these every 2 weeks on various topics until the end of the year. So there might be some other relevant ones that you want to jump on for, or they will be available for replays as well. My email address is there too. You're welcome to email me within reason. I'll answer questions sort of within 24 hours. Not when you get too specific and it's actual personal advice, obviously. So just use some discretion there, but I'm happy to help you along the way as much as possible. One of the other benefits, I suppose, that has happened because of COVID, surprisingly, is that we can now witness people's documents virtually as well over Zoom, just like this. So you don't actually have to go in and see a lawyer anymore if you didn't need to. You know, it can all be done online. Let's see if I've got all these questions. I'm just going to stop sharing my screen. I'll put my email into I might just turn a light on as well. Q&A, chat. So I'm just putting my email address into the chat box there. So if any of you wanted to copy and paste that, you've got that there. All right, so I have a blended family, so I'd love to know when the webinar is that discusses that in more detail. Yeah, good question. So let me check my dates. Superannuation is next. Probate and deceased administration is 2 weeks after that. Then avoiding claims against wills, then peace of mind, then blended family. So you're sort of looking at maybe 2 months. On our Facebook page, on the events page, they're all set up there already. So the exact date will be there. So watch out for that. What else is in here? I think I should have been ticking these off as I go. Sorry, they're all not staying in order. What about if an adult child is on disability pension and if an inheritance comes along? Yeah, okay. Yes, an inheritance would potentially impact their disability pension. If it could push them over the asset test for a full pension, so then that they would drop down to a part pension. But there are tricky trusts that we can look at for disabled children as well. Do some research on a special disability trust. So that is a trust that you can put inheritance in that Centrelink actually approves and then doesn't count. And I think you can have up to 650,000 in there that is not counted by Centrelink. So that's a tricky little thing that we can do for disabled adult children. I think that I might have got everything. Let me have a look over here. Thank you. That was very helpful. Thank you. Key takeaway was around the explanation of the super. Yeah, single and have no children. So you want to direct your super into your estate, and then in your will, you can say how that's dealt with. Can't see an email in the chat box. I'll pop that in again. You might have opened the chat box after I'd done it, so you wouldn't have seen it from before. So it's there again. Yeah. So just in case you didn't have that, that's there. All right. Someone else just put another question in. No, I think I've got them all. All right. Still can't see it. Maybe it's new. No. Let me share my screen again so it's back up on the screen. And then go back to the chat box. You know what it is? There we go. Silly me. Here I am typing it, but I'm typing it not to everyone to see. So now it's in the chat box. You should be able to see that. All right. Yay. Yes. Good. Found it. Fantastic. All right. So I hope I got everyone's question. If not, grab that email. By all means, email me. No worries whatsoever. Watch out on our Facebook page for further events coming up. Heaps more up to the end of the year. And I will have them all as replays. So I'll email you this replay. If not tomorrow, then it will be sometime over the weekend. I just have to make sure I upload it first. Good. I'm glad that that's been helpful.